It is a collegial exercise. I think what works best, just as an aside, I don't think that takes away at all of the strength of your individual view on the law. It doesn't. I think what it reflects, and I think that's an important quality, is to have perhaps a bit of humility. It's not about you. Get over yourself. It isn't at all about you. And have that kind of humility, not just about your person, but about your thoughts and opinions and ideas. To have an open mind that there are other reasonable ideas out there, and hey, lo and behold, they might be better than yours. and be able to accept that. It doesn't take away from yours, it strengthens your view. So I think that's important. In personality-wise, it's important to be able to work with others, because it can get difficult to work with the same 8 people all of the time. I've often said this is like an arranged marriage where someone chose 8 spouses for me and I had no say in the matter, all right? It's just about that. So you do have to have those personal ability to remain civil, to have a working relationship with 8 different personalities, because that's crucially important to the institution. I don't think that we can give the same service if we're all in our individual offices with the door shut and we're not talking to each other. So personality, I think, is important that way. I think that it's important to have someone who will have a healthy attitude and can find a balance and can keep a sense of humor and not be totally taken. And it's important to have other interests and to take time to do other things, because it could be all-consuming. It could easily be all-consuming, and I think it cannot be. You're not going to do your job properly. You're going to have a very tired brain and body. So those are qualities that come to mind on a personal level that are important. In terms of the process that is in place for our deliberations, there is no firm rule at all. You ask me if we are dealing by way of memos or we talk to each other, all of the above, frankly. And we don't talk a lot before a case. I think we're all too busy preparing for it. There's no rule forbidding it at all. And it may well happen. You see a colleague in the hall, what do you think about tomorrow's case? I can't figure out that argument at all, or whatever. So there can be. So if conversations before a case will happen, but it's really informal, of the nature that I'm describing. After a case, there is a process in terms of who writes or what, and it's part of how we communicate. At the end of a 2-week period, the Chief Justice assigns who will write the majority opinion. It could be unanimous. If there are dissenters, they'll decide amongst themselves. So the process starts there, and we all wait till the majority opinion is circulated. After that, how do we communicate? It will vary. There are a lot of memoranda going around. You don't have to communicate just by memo. The usefulness of it, I'm a believer in memos. I find it easier to put my thoughts into writing. It's easier because I have to move on to another file afterwards. And also, I may be making a point that is troubling 3 or 4 other colleagues. So it assists that they don't have to all do the same thing. So I feel very grateful when I see a memo from another colleague as well. Yes, I was concerned about that, so I don't have to spend hours putting it together. So the memos are very useful, and we are 9, so we're not all gathering around the water cooler every morning. And there are times of year as well where we're more dispersed. So that's the strength of the written memo, because we're all aware of the comments of the others. There will be a lot of one-on-one discussion as well, where I'd be more inclined to go see the judge. Perhaps it's a question at times of more of style, or those issues where it's not worth bothering everybody else with a memo. I just go see the judge and say, that sentence, I don't know why, every time I read your judgment I trip over it, and perhaps it would be better said this way. Or sometimes I'd go one-on-one. It's easier than just writing a whole memo about it. Sometimes it's more delicate. You see a phrase where you say, this could be not well taken, and some people do prefer. They feel more comfortable with the oral communication. So it'll be all of the above. But there's a lot of deliberation after a judgment is circulated. With some cases less than others, obviously, if everyone is on the same page on the analysis. But with some, there's quite a few, and the judgment can change a lot in the process between then and until the final one is. Let's say the first reflex is not, oh, well, I don't agree totally with this, I'm going to write. And I'm glad it's like that, because I think concurring opinions can enrich the law, but you have to select, or you have to be careful when you write a concurring opinion. It should be when you frankly cannot agree with part of the analysis, where it will add something. But I think the better reflex is to go to the author and say, I have difficulties with your paragraphs 2 and 6, and here's why. Chances are he or she will often agree with you. It's part of that process where you're identifying, oh, there might be a fly in the ointment here. And it's much better than having, because what happens, you could write a concurring judgment and then the author says, oh, she's right, I'm going to change my paragraphs 2 to 6 because it's not etched in stone. Then you've wasted your time. So there's a lot of communication between the court. And this is the time I've been here, it's a good court. I've been told that before, and the communication is always open. And I think that's how you can deal with, you don't wake up in love with your 8 marital partners every morning. Obviously not. But I think you have to be focused on the task. It's not about you, and it's not about them as persons. And you got to repeat that to yourself when times get difficult. And indeed, with some people, it's easier to send a memo than go speak. Personalities are different. But I think we have a very good court. It's civil. The communication lines have always been very open. I've often said to people, my measure of if a work environment is healthy or not is the amount of laughter that you hear. There's a lot of laughter on the second floor. We may be laughing at each other, mind you, or our judgments, but we laugh, and that's very important. So it's a good court, and I'm hoping it will continue to do so, to be so.